my. It is January the 23rd, 2026. And this, ladies and gentlemen, is the beginning of the winter snowstorm of the century? Millennium? I don't know. It's more than that. It's the court gallery. Oh my. More than a few of you probably know what is in store tonight. If you've read the description, you probably have a really good idea. We are going to be spending the whole night with Judge Middleton yet again. It is his last year of service in Centerville, Michigan. And ladies and gentlemen, we're going to spend as much time with him as possible. But more than that, the last 2 days have been utter disaster in the courthouse. The courthouse flooded yesterday. It's been a whole dramatic scene. Judge Middleton is going to tell us all about it. We're going to pick up with Judge Middleton's intro from yesterday. He didn't actually have any cases yesterday because of the courthouse disaster. Then we're going to jump over into today's proceedings. We got several landlord-tenant issues to deal with before we get to the coup de grace, which is, of course, the AI debacle with the Amish couple who are the Yoders. And ladies and gentlemen, it is as crazy as you think it is. We all thought the Yoders, this situation was done, but how can it not be? I don't know. You know, if you've seen it, you know what you got in store. Blackboard's live. We got all the snark that you can shake a stick at, and it all starts right now.
Good morning, everyone. This is not so much as a court proceeding, just sort of letting you know what's going on. The courthouse, at least part of it, is flooded. The heat is off. We got a text about 6 a.m. saying the heat is off. And there's a 2-hour delay. So all the employees, except the ones that didn't read their text, are home on a 2-hour delay. I came in anyway because I was going to supposedly do a hearing from the prison. Some guy was going to zoom in here at 8:15 from the prison, and there was no way to tell him what the deal was, so I came in anyway. Well, it's a mess. My office is flooded. The back hallway is flooded. The probation department is really flooded. It's all squishy when I walk through the carpet in my office. It's cold. It's probably about 50 degrees in there. So it's all around unpleasant. So whatever was going to happen at 8:15 isn't going to happen. The courthouse is on a delay, so Judge Patterson's cases have all been adjourned. I have some personal protection order matters at 10 o'clock. We'll see whether those take place or not. I have pre-trials this afternoon. So basically, it's a mess. So yeah, early start to the construction. We were going to start moving. They're still trying to do the move by March. That's all going to be terrible. So yeah, this is incentive to start to move stuff earlier. So that's it. So I'm sitting here. It's relatively warm in the courtroom. It's not flooded. And nobody showed up from the court. So I could have slept in for 2 hours, but I was already up by that point. So we'll do today's first line. I don't know whether we'll be back here or not. Hopefully they'll get the water shut off and maybe the heat can come on, but I think it's going to be a while before the heat comes on. So another day in paradise. So I'll leave you with this. Son of a gun. You walked into the party like you were walking onto a yacht. Your hat was strategically tipped below one eye. Your scarf, it was apricot. I hope you guys liked Mr. Brightside yesterday. Everybody should know this song. Anyway, we'll hope for the best. Son of a gun. Yes, we've been through this in 46 years around here. All kinds of plumbing, heating, electrical problems. Just another day. We'll survive. But my office is going to get moldy. I don't like that. All right, everybody, you have a good day wherever you are. It is still a beautiful day, and it is great to be alive. But we're going to stop the live stream. Good morning. Today is a beautiful day. Great to be alive. It is January 23rd, 2026. All the schools are closed. It's about 8 degrees and falling. My office is a total disaster. After I left yesterday, the Surf Pro guys came in and took everything out of there. There's stuff all over the place. File cabinets, files, random stuff. And so it's messy in there. Also, it's got about 10 blowers in there. It sounds like a wind tunnel and it smells like wet carpet. So I'm going to do most of my operations today, from in here. We did reschedule the stuff that we missed yesterday for Monday. It wasn't too bad. It could have been worse than it was. So we're back to work. I've been gone. Things are a little bumpy, but we're going to do our landlord-tenant docket today. We got further hearing on the Colon Township versus Yoder zoning matters. I'd hope that thing would be over and done, but we're still struggling with it. As I said, I've got a full landlord-tenant docket, and we're going to get started. We always got business to do. We were going to move. They wanted us to move in March, but it looks like we're scheduling our move in April. So all this stuff that got wet was going to have to be moved anyway. Our probation department is completely flooded. Their offices were decimated. The ceiling collapsed and all over their equipment. And some of them have already started to move. And the probation department is moving also. So I guess we're moving a little early. But life goes on. We have work to do, and there's no sense to complain about it. We'll just get back to work. Today's first line is somebody at my age would know. It's a great song, maybe in my top 10. The love-struck Romeo sang the streets a serenade, laying everybody low with a love song that he made. Finds a street light, steps out of the shade, says something like, "You and me, babe, how about it?" A love-struck Romeo sang the streets a serenade. Great song, great lyrics. If you don't know it, look it up, listen to it. I bet you like it.
Good morning, Your Honor.
Good morning.
I think you may have seen that Attorney Larson and I were on the phone in anticipation. I know that you were
Well,
looking.
there's more going on here.
Yeah, I caught that just a second ago.
At about 8:30, the staff asked me if I would do a mental commitment hearing in absence of Judge Kane, who's about to go on a warm weather vacation. I thought he was already left. I said, well, who is it? I want to know. Well, it's Kevin Stroop. Pivotal, our local mental health agency for St. Joseph County, is filing a petition for a pickup order for Mr. Stroop.
They contacted me yesterday, Judge. So I am
You're aware of it?
I knew that was on their list of possibilities. I didn't know the status of it.
Yeah, well, for Miss Larson, I'm not gonna, as we all know, Mr. Stroop has been suffering from paranoid schizophrenia and has been an active client of Pivotal for several years. This case got a long, complicated history. We had a...
Judge, should you call the case? Or?
Yes, I'll call a case. Thank you.
Yeah.
Thank you. It's TJ Pine Valley Place versus Kevin Stroop. File number is 252656LT. Attorney Joan Larson is here on behalf of TJ Pine Valley Place. She's had a history with this file. It's very helpful to have the same lawyer in these complicated cases. And Meg Bauer is here from Legal Aid on behalf of Mr. Stroop. He has had a perpetual and long time bed bug problem at his apartment, and the complex has been trying to remediate it for several years. We had a consent order which didn't work, and the plaintiff attempted to enforce the consent order with a termination of tenancy. Defendants counsel through Ms. Bauer objected. There were some technical issues regarding doing it as a violation of the consent order. So it was agreed the plaintiff would simply refile a termination of tenancy, which they have done. And this is the first hearing in that regard. As I mentioned, I was asked to do a mental pickup commitment hearing this morning as a cross-sworn probate judge. We're all sworn to cover for each other when we're gone. And I'm the judge that does the mental health pickup hearings when the probate judge is gone. I do, I don't know, several a year. And very often I already know the people because they're connected to district court cases, and that's the circumstance here. I won't go into the details, but Mr. Stroop is in very poor physical condition. He's not cooperating with mental treatment. His apartment is filthy. He's filthy. And I think he just wants to die.
He is still receiving his mental health medication, as far as I understand.
All right. Well, at any rate, there's a hearing at 9:30 in the probate court. Judge Kane elected to do it himself before he leaves on his trip. So this is a just cause termination for the reasons I stated, a long-term problem with bed bugs in this apartment and other issues. My hope was at some point Pivotal or another agency would find alternate housing for this defendant, but he's very difficult. He's very difficult to place. I'll leave it at that. So this is a first hearing. Ms. Bauer's got a very good grasp of the circumstances, and so does Attorney Larson. So we need to set it for a second hearing. Ms. Bauer, do you have any further insight on this?
I know that Pivotal has worked on trying to find alternative housing, but there are a number of barriers, including some questions about the voucher. Ms. Larson did inform me this morning that he may have his voucher back, but that doesn't align with my understanding of how vouchers work. So I'm curious to get more information about that. At any rate, the defense would object to the allegations that they rise to just cause, and that that he has acted as they have alleged he has acted, just for purposes of covering an answer here. But we certainly don't know what's going to happen with him at 9:30 this morning, and
Well, we
I've
need to
submitted
set a
written
second hearing.
answer.
And as I indicated, when we were in the context of non-compliance with the consent order, there were some very technical requirements that the defendant claimed needed to be met. Now it's just a general termination of tenancy for just cause going back several years and the whole broad context of what was what. But I still expect this isn't going to go quietly.
Your Honor,
Yes, Ms. Larson?
I do want to let you guys know that there is a condemned sticker on his door. We did take over the property not that long ago, so I personally don't know a whole lot on behalf of Mr. Stroop, but there is a condemned sticker on his door. And Chief Hayden called yesterday and said he had went and told him that he was not supposed to be there, and he simply said okay and shut the door in his face.
Judge, first, that was not Ms. Larson. That was someone I'm not familiar with who that was.
All right, well,
That's
that's,
the
why don't
property
you, Ashley, why don't you go ahead and
manager.
Ashley, why don't you state your name for the record?
Ashley Kasner,
And what's your position there?
property manager.
And Judge, my understanding is that this property was sold in December. I was on the phone with Mr. Stroop when Fire Chief Mike Hayden knocked on the door. He was operating in fire chief capacity. So I was actually there.
Well,
for the
he's not just the
interaction.
fire chief, he's also the zoning enforcement officer.
That's
He's a
why I
fire
said
chief
in that
at Colin.
capacity.
And Constantine, he's the building inspector. Oh, this is Constantine. So I'm not sure what his capacity was.
I spoke with him, Judge. I spoke with him while he was there speaking with Mr. Stroop, and I spoke with him after the conversation with Mr. Stroop. But I can represent as an officer of the court that he absolutely did not slam the door in Officer Hayden's face, because the three of us had a conversation together yesterday.
I don't think she said
Officer
slam.
Hayden was there because Pivotal called 911 to attempt to get him to leave with EMS. He declined medical service. And in fact, Officer Hayden expressed to me that he made very clear to Mr. Stroop that he was there in his capacity as fire chief, and that he was not
Your
trying
Honor,
to
I have to
remove
object
Mr.
at this
Stroop.
point to Ms. Bauer putting in conversations that I was not a party to.
Yes, we're getting all over the place.
Well,
We're gonna have a second hearing on this place. At some point, he's gonna have to get out of there. The properties, we now learn, has been condemned. And so I don't know what the status is. I don't expect this is gonna be straightforward or simple. But because they're trying to find a place to put him.
But Judge, I have to advocate for the representations made about him, and so none of this.
Well, that came out of the blue as in defense of you, Ashley, although it was helpful information to learn that the property's been condemned. And I was unaware of it, and I'll see what further information we can get. All right, I have a wide open next Friday afternoon, but my fear is that's too soon to put this.
In light of the fact that we don't know what's going to happen at 9:30, and there's a lot of voucher questions, I would agree that might be a little soon.
The
I
only thing I
understand
will
the
say,
plaintiff
Your
has
Honor,
an objective, though.
Well, it's not an objective.
All right,
The only
Ms.
thing I will say,
Larson,
Your
what's
Honor,
your position?
I am leaving my office effective next Friday and going to work for the court. The Ingham County Friend of the
You're
Court.
going to work where?
Ingham County Friend of the Court.
Oh, okay, congratulations.
Congratulations.
Thank you. Thank you. I will be leaving private practice. My last day is actually next Friday. If there's any way that hearing could be done via Zoom, I think that, I mean, this case has lingered for a very long time, Your Honor.
I apologize, but we are gonna be able to do this next Friday on your last day. Some poor other associate's gonna inherit this, but I'm gonna set it for 1 o'clock, 1:15. For February 13th. By Zoom. We don't know what his medical status is. We don't know what his pickup status is. We don't know what the condemned status is.
Your Honor,
Yes.
will that be scheduled as a second pretrial, or is that going to be the actual trial date?
Well, let's call it a second pretrial. I'm not sure we'll be ready to take testimony. I've got the whole afternoon. Well, the problem is this keeps going and going and going and this condemned. So let's set it as a trial regarding termination of tenancy.
That would then be in person, Judge. This-
Generally, in person is what I do for testimonial trials.
and that
Every
is-
time Mr. Stroop comes, we have to spray for bed bugs after he leaves. His health, I'm guessing he'll be able to be here. Now, you also mentioned there's new ownership of Pine Valley Place,
Yes, Your Honor.
but the new owners, I think, want the same owners were.
Yes. And I know, Your Honor, if we have to get into witnesses as far as the exterminator, she is not local. She's like two or 3 hours away, and so are all of her crew.
I'm going to allow this one to be by Zoom for all concerned.
Thank you, Your Honor.
For purposes of the record, the defense objects to remote testimony.
All right. And you can preserve that objection. Things may change in that amount of time as things develop with the mental health case and his medical conditions and the condemnation. Their case in chief may be the fire chief came, inspected the property and condemned it. We wish to terminate his tenancy because the fire chief has condemned the property. That takes out bed bugs, a whole bunch of other stuff. But we'll see where we are. Certainly, I'm willing. I know you guys have been talking about this case. Ms. Larson, best of luck to you. You've always done a fine job representing your clients here. This has been a particularly difficult one.
Thank you
But
very
we'll
much, Your Honor.
continue it to February 13th at 1:15, and whoever your successor is. And let's see what happens today with the mental health case, what happens with his physical health. And before you leave, maybe we'll have more knowledge on how to proceed. But we'll have it scheduled for that date. All right, thank you both.
Thank you, Your Honor.
Now, with a just cause termination, the defendant doesn't have the right to redeem the property. It's just cause to terminate because the rent has been late 3 times in a 12-month period. The landlord has the discretion to accept payment, but in that circumstance, the court orders that the defendant has 10 days to vacate and 90 days to move or sell the mobile home. And that law doesn't apply when it's done this way. So we're in the Wild West, and as far as I know, no one has actually removed a trailer from a lot. But Ms. Cantrell, let's talk about your case. We're kind of in the same boat. And let me note everybody that's here. Ms. Cantrell, can you hear me?
Yes, I can.
All right, Mr. Cantrell, in this case, you submitted documentation that the arrearage is $1,932.80 plus other of $124.45 plus costs of $249.20 for a total of $2,306. Is that still accurate?
That is, Your Honor.
And again, that's through January?
That is correct.
And do we know what the other is?
Yeah, there's a couple things. So there are some late fees in here at $60 a month, and we can correct that to whatever number you want that to be, Your Honor. And then there's also some utility charges in here. There's $124.45 in utility charges that were not paid for November or December. That's what the other is.
All right, well, that's straightforward.
Yeah, the
Utility.
rent, the $1,932.80 in rent includes 4 late fees at the rate of $60 a month.
Ms. Cantrell, what's your circumstance here?
Well, I mean, I was making payments on my rent, but they were applying it to everything else. I had my rent paid forward, up until September 1st, but because they just kept taking money out of my prepaid rent, it threw my bills into a tizzy, and I'm still trying to correct it. I've actually been in contact with DHS and Neighborhoods Inc. to get help to get all of this caught up. It's
All
just
right.
hard to do it because they combine the water sewer bill with rent, and most places want those separate.
Yes, this park has perpetually had water and sewer problems for 50 years. And so if I understand, and there's previous cases, instead of applying your money to rent, they were applying to water and sewer costs.
Yeah, instead of keeping it on my rent. And I didn't have a signed lease with them until September 1st of 25.
All right, well, how much is the water?
I don't know because they throw my water bill all over the place. In July it was $240 some, and then 2 months later it was $60.
How much is your sewer?
That's all into the water bill.
Oh, so sewer and water included?
Yeah, and sewer is usually a lot more than the water bill.
All right, well, just as a ballpark, what is your sewer and water per month?
For if I'm basing it off the last 2 months, roughly about $72 a month.
For sewer and water?
Yeah, or less. But they had 2 months, I believe it was either June, July, or July, August. They charged me for 17,500 gallons, and then the next month was 24,500 gallons. I don't see how that's possible for one home to use that much.
They have a third party contractor that measures their water, and it's unclear exactly what's going on out there. And how much of your payment is being applied to water. And I don't know what the last case didn't have a lease. This one, there is a lease.
I signed the lease back in September because they
Yes.
told us they were going to charge us an extra $50 a month if we didn't, and I couldn't really afford it.
The lease shows a late fee of $50 a month. We may be able to live with that. Anyway, so you've also applied for assistance. So Mr. Sickle, the 1932 is just rent and 4 late fees?
That is correct, Your Honor.
And when I was talking to Meg, we found 6.
Well, it's-
All right,
correct.
and then the utilities would be the sewer and water bill that we're talking about.
That's correct. Yeah, no, Your Honor, I mean, I will say it's a little bit complicated to sort all that out. I mean, we have one account that they measure, right? So the ledger that I have for the tenant has all of the tenant charges in there. So this goes back several years. So if they get a payment, they apply it to the oldest charge that's outstanding. So it's all lumped together. So to say what's been paid and what's not paid, I mean, it's not quite that simple.
I agree. So they throw some spaghetti at the wall, hope it will stick, and then the tenant's trying to figure out how much they actually owe or what their money got applied to.
Well, we do know what, right, we do know what she owes, right? I mean, the number that she owes is the number she owes. I mean, we can argue about, well, when a amount for $400 comes in, is it for late fees? Is it for water and sewer? Is it for rent? Right, but the total amount that's shown that's owed is what's owed.
Yeah, that's the spaghetti sticking to the wall. Trying to figure out how they got to that number is not always easy. Anyway, we're gonna continue this along with the next case to 1040 next Friday, January 30th, 2026. Now, Miss Cantrell, same thing. Another month's rent and utilities are going to be due.
Yeah, and my husband works. He gets paid every 2 weeks. I have part of February put up already. His next check, I should be able to cover February and the water bill that comes out here, I think, in a couple of days.
All right.
I just have to get the help to get the water that's
Well, those are the numbers.
and
1,932, 124, 249 for a total of 2,306.45. All right, I could save myself a lot of grief if I just disallowed these non-payment of rent cases for lot only. But for example, you're trying to get financial assistance from DHS and Neighborhoods Inc. You wouldn't be able to do that because it would just be a termination of tenancy. That's why I allow it. And I've said this 100 times, the law needs to be fixed either by court rule, by statute, or opinion from the Court of Appeals, but none of those things have happened. So we're in the Wild West. This part of the Wild West, we allow them to do it, but it causes lots of other problems. All right, I will see you next Friday at 1040. And Mr. Sickle, I'll see either you or Mr. Cromendike. And eventually maybe we'll work all the issues out for this park and go forward from there. All right, thank you.
Good. Thank you, Your Honor.
All right, Mr. George is here on behalf of Alarkans, and also present is Brady Watson and Miss Andrea Watson. So Miss Cantrell, I'm going to go ahead and remove, she left. So let me make a note. This is filed as a demand for non-payment of rent. This is a standalone home on South Constantine Road inside the city limits of Three Rivers. Andrea Watson, can you hear me?
Yes, Your Honor.
Brady Watson, can you hear me? Mr. George, what's the status here?
Your Honor, I was provided an update last week that the current amount of back rent is $3,575. There's $200 in late fees. That's at $40 a month. Total costs is $234.93, and the total amount is $4,009.93.
That is through January.
Through, yeah, January 15th was the date of the
Through
update.
January 15th. All right. So there's going to be another month calculated in here somewhere. Miss Watson, Mr. Watson, what's your position?
We are trying to save up some money to get it caught up. My husband had lost his job in October, and I found out I was pregnant and was having a really hard time at the beginning of my pregnancy and was missing some work, and my work slowed down. But he has since found a job making more money than he was at his previous job. And I am now back to work. I just went back from a 2-week layoff this week. So we're trying to get it caught up. And the property manager, Caitlin, said we could talk about getting a conditional dismissal of eviction depending on how much we had in court arranged payment plan.
Very good. Well, the first thing we're going to do is we're going to adjourn the matter for 7 days. We're going to adjourn it to next Friday, January 30th at 10:50. These cases are much more straightforward. There's just rent, there's a lease, there's an established late fee, which is reasonable, and their court costs. You and your husband are probably good tenants. It's easier to keep a good tenant in there than to move one out and move another one in. And I did mention the conditional order of dismissal. The Alarkans generally work with their clients to try to get caught up. You're both employed. You wish to maintain your tenancy. If it can be worked out, it can have a conditional order of dismissal filed next Friday. Also, on February 1st, another month's rent is going to be due, and the rent is $975 per month. So take that figure of $4,009. What's actually going to be due is about $5,000. So keep that in mind. I don't know if you're asking for any emergency help from DHS or otherwise, but we'll discuss that further. We'll do this again by Zoom next Friday. Yes, you want to say something else?
I have asked DHS for help. They have denied me because my oldest daughter's dad was very abusive, and I don't have any police reports to show them to stop them from trying to make me go after him from child support because I don't feel safe with him knowing where I live.
All right. Well, how about try Neighborhoods Inc. also?
They have told me, and at the time I applied to them, my husband was unemployed, and they told me with just my employment, I made too much.
All right. Well, there is that. You're too rich to be poor and too poor to be rich. All right. Well, let's see where we are next week. It sounds like you guys are trying to do the best you can. Mr. George, anything to add on this?
The only thing I would add, Your Honor, is that I did file a limited appearance for this hearing only. I don't know whether that's going to expand my representation into further hearings, but I'll get that information over to my clients and make sure that they're aware of the hearing next week and everything that was said at the hearing. Thank you.
Well, I appreciate you're doing some of these. You're seeing perspective of the issues we're struggling with, and we'll see where we go. All right. Someone either will be here. The Alarkans, Caitlin, their manager, she's also quite capable. But Mr. George is here for today's appearance, may or may not be here for the next one. All right. Mr. and Mrs. Watson, you're good to go. All right. We've got Mr. Bradshaw. We've got Ms. Richmond, and we've got some 10 o'clock civil matters. Mr. Barta, I apologize. We're a little backed up here. So let's take care of our last few of these and we'll see where we are.
Your Honor, may I just ask a quick question?
Yes, sir.
We submitted a fully executed consent order with installment payments to the court. I just want to know if I have no problem.
Okay, in which case?
Capital One Bank versus Carol Ritchie.
We had a flooding incident yesterday and the courthouse was closed. My office is full of blowers and wet carpet and stacked up boxes, and it looks like a well, it looks like a accidents. I don't know what it looks like. Looks
Sorry
like
to
it got
hear that.
flooded. So I don't have any reason to disbelieve that. So the staff wasn't here yesterday.
No problem.
Elaine, do you see if we've got a settlement in Carol Ritchie? Are you here only on that case?
That is correct, Your Honor.
All right, I'm gonna let you go. Plaintiff has submitted executed settlement.
And I believe that was faxed at 11:55 yesterday morning.
All right.
Hopefully the fax
All right,
machine.
I won't
wasn't-
make you stick around for that. I'll take you as your word. And so it's just as cold there as it is here, but it isn't flooded. So you have that going for you. It could be worse. You could be in Big Pine Key, Florida, struggling.
I was going to do this outside, but I didn't want to torture you guys.
All right, Mr. Barta, I'll see you next time and we'll
Thank you.
look for that settlement order. Thank
Have a
you.
great day.
I'm working
You know
on
what
it.
you're talking about, Terry? It's really warm up here.
I got a call from Lydia this morning. She's trekking through snow, and she said
Yes.
she was watching her thermometer just go down. Just
Well, the snow isn't so bad. It's supposed to, a bunch of it is supposed to come. But let's take care of your cases. Mr. Espin
Yes, Your Honor.
is here. This is a continuation of file number 252644LT. We determined last week that rent was $2,709.89.
It was on the fax machine.
All right, that order was on the fax machine and I'll execute it here in a minute. So Mr. Bart is good. 170 in cost. We determined that through January 8th, rent was $2,888.91. Miss Richmond, what's the current status?
well, he made a substantial payment. His rent now is $732.39 through the 29th of January. Court costs of $179.02 for a total owing $911.41.
Very good.
I also have money I'm dropping off tonight too. I just didn't have
all
time
right.
yesterday after work.
Okay, thanks. Thanks, Robert.
Rent here
You're
is $167 per week. But I find that through January 29th, rent is $732.39.
That's correct.
Miss Richmond, you always do a good job with these. I don't have to figure out what's what, or was there a hidden fee I don't know about, and you always calculate it well.
Well,
I
thank you.
wish everybody did that. 9/11/41.
Yes, sir.
Mr. Espin, you have 10 days from today to pay that. Today is the 23rd, so that would give you until February 2nd.
I will have it all paid up by then.
I expect you will. No money judgment is entered this time. Partial payment will not prevent the writ of eviction. And the date for the appeal is 2/2/26. Pay some tonight and pay all.
Yep.
All right.
I didn't know.
Mr. Espin, you're good to go. I think this one's gonna work itself out.
All right, I appreciate everything, and thank you, Terry.
Okay,
All
thank
right.
you, Robert.
You're welcome.
Not that I really want to make ourselves feel worse than we already do, but I am gonna be in that neighborhood in February. What is the temperature in the Keys right now?
I think it's been chilly. It's been going down to the 50s, but today is beautiful. I think it's in the 70s right now. Larry's getting the boat out.
Maybe the only place in the continental United States that is in the 70s, but all right. Robert and Melissa Grant don't appear to be here. This is file number 252673. Just a minute, let me turn this off. What's the current status here?
Okay, through January, they owe $1,331.56 for rent. $183.65 in court costs for a total of $1,515.21.
They were both personally served. They don't appear to be here. Is anyone here on behalf of Robert or Melissa Grant? And you always send me a judgment. I wish I could train some of my lawyers as well as you are.
It's part of my routine.
Well, you must have been trained by the Bradshaw Law Office, so I don't know. You've got a.
You trained me.
Yes. Total is $1,515.21. The date for the writ, oops, this is a default. They were both personally served as February 2nd. Partial payment will not prevent the writ of eviction. No money judgment is entered at this time. And the date for the appeal is also February 2nd. Do you think that they're going to pay?
I don't know. Sometimes they just show up with $1,500 and get it mostly taken care of. And then they don't pay for a while, and then kind of an ongoing thing.
Well, it's difficult to find tenancies, and it's difficult to find standalone dwellings at these rates. $765 a month for a house is about as cheap as you're going to find in the current market. So you've got a waiting list of people that probably like to rent this. At any rate, I expect what they're going to do is pay this. 3,331.56 in rent through January.
Correct.
183.65, and the total is 1,815.15.21. All right, we got one more to go. Raymond Schwartz is not present. This is file number 252642. This is a second hearing in the matter of Terry and Larry Richmond versus Raymond Schwartz. We determined last time that through January rent was $1,583 plus cost for a total of $1,693.
27.
Am I right? 27.
Yeah, that's the same. He hasn't made any more payments.
Is he still there?
As far as I know, he was a month ago. He's been there a long time.
Let me make sure he's not here.
Okay. He was there last time.
He was here last time. I'm looking for Raymond Schwartz. All right, thanks. Bye. Yeah, he was physically here last time. He knows what the numbers are. They're the same as we discussed previously, and the same thing. He's caught up in the past. find by default that through January, rent is $1,543. $1,548 in costs. And the total is $1,693.27. Excuse me. That is due by February the 2nd. No money judgment, partial payment will not prevent the writ of eviction. Of course, February 1st, another month's rent will be due. All right, the defaults do help us catch up on our docket. Now we're only 18 minutes behind.
Good.
All right,
Glad I
Ms.
could
Richmond,
help.
enjoy the Florida Keys and think about us. But that's why you're there, because you want to avoid this. I can't complain. I just had some warm weather vacation myself. So but it's back to it. All right, I'll see you next time.
All right. Thank you. Bye, guys.
All right, this next matter is Riley Wesson versus Lacey Greis. This is a house on M86 in Centerville. Miss Wessel, can you hear me?
Yes, Your Honor.
All right, rent here is $1,000 per month. What's the current arrearage?
For October, November, December, it was $3,000 and then $50 a month in late fees, so it was $3,150. But now we're in January and it would be another $1,050. So it would be $4,200 altogether right now.
Ms. Greis, do you agree?
I do, yes.
I do, yes.
I have a little bit of money in my savings that I plan on giving Miss Riley.
All right, well, let's talk for a minute. Let's also calculate the court costs.
Okay.
We got a $55 filing fee and a service fee of $32.20. So the total is $87.20 in cost. Total through January would be $4,287.20. You might as well figure on adding another $1,000 for February before we get to where we get. So, all right, let me back up a minute. You intend to pay some here soon?
Yeah, I do. I reached out to DHS before we even had a court date. You know, I asked them if they could help me. They said the only way that they could help me is if I get a court date. I spoke to Miss Wessel and I told her, you know, like DHS said that they'll help me if we can get a court date.
Right, well, you've got a court date.
We got a court
so I want
date,
you to
yes.
share this information with them.
I applied to DHS before the court date. They denied me because we didn't have a court date. I've applied 2 separate times, actually 3 now. They denied me 2 times for being in non-compliance for child support. I called the 1-800 child support number. They said that's an error in DHS's system and that they would email them. So then I called DHS and I told them exactly what child support had said and that they would be sending an email. They told me the SER forms are very, you know, like tricky. Once they get denied, you have to reapply. So I reapplied, immediately got denied again for being in non-compliance. So yesterday I spent all day doing the same thing. I spoke with DHS. They said that they are going to submit a ticket, like stating that there is an error in the system so that I don't get denied for being in non-compliance. Like I don't have any open child support cases.
All right, well, we had another lady this morning that had the same sort of issues.
Yeah,
But I'm
heard
going to
that.
continue this for a week to January 30th, 2026 at 11:05.
I'm trying
I
to
would
get
appreciate it
DHS.
if you could both be by Zoom. If we have to do this by telephone only, we'll do the best we can. Miss Wessel, let me tell you
Yes.
some things you need to know as a landlord. If we have a hearing next week on January 30th, I'm gonna make a finding on how much the rent is, and I would give her 10 days to pay the rent, or she would be subject to being evicted. That would be on February the 9th. You don't have to evict her on February 9th. You have 56 days from that date to ask for the writ of eviction, and another 56 days to serve it. So you can work with Miss Greis to try to get caught up on this back rent. But Miss Greis, you need to know that by the letter of the law, if you don't pay it, she can move to evict you. She's gonna be $5,000 plus behind. And it's gonna be very difficult for her to collect that. Same thing, she probably has someone that would like to rent this property. And so you need to stay in contact with your landlord.
Yes,
And
absolutely.
but we'll address this further. Share this information with DHS that you're gonna owe $5,287 plus 50 more.
My plan, I had asked DHS to help me with the 3150, and then I can pay January's, and then I'll be able to pay February's and kind of get caught up. I just kind of need help with them paying the 3150.
All right, well, hopefully they can give you some. I
Yeah.
did see your form that you had filed for the assistance.
Yeah.
We'll see this. If we need to adjourn it again, we can, but right now I'll just leave it for that date.
Yeah.
All right, thank you.
Thank you.
All right, we're a little behind, but it could be terrible. Somebody's logged in as mommy. I know that's not their name. Who is logged in as mommy?
That would be my daughter.
Well, what's your name?
This is Randy and Patricia Winters.
All right.
We kind of tired, Judge. We worked all night.
Well, all right, we'll try to get through this.
Okay.
Now, we have a clunker next. We have Vicki Demire versus Randy Winters and Patricia Winters. The Winters were here. I lost them. They've been up all night. Mr. Dutka is here on behalf of the plaintiff. I hope I didn't accidentally X them out here. Good morning, Mr. Dutka.
Good morning, Your Honor.
Yeah, they were here and I lost them. So let's see if they log back in. Now, they had indicated they had contacted Aiden Freeman at Legal Aid and he was going to be filing an appearance, but I don't believe I ever received an appearance from Legal Aid. Did you, Mr. Dutka?
No, sir. No contact as of this morning. Nothing on my email. Nothing on my telephone voicemail. I haven't gotten my regular mail as of today, but I'm assuming nothing.
Judge, that would probably be Adam Freeman, and I will
Okay.
look at our system. Although I guess I could be mistaken.
Well, they may be mistaken. As I said, they were here. And this matter was set for today at
Actually, 10:30, Your Honor. It's,
10:30. So we're not there. We're actually ahead of schedule. We got caught up.
and I see Mr. Demire isn't present yet either. So, and I know he was going to call in.
All right, let me take these couple files out here. Good morning. I'll be right back. I think they're back. I hate to even go out into my office. It smells like a tarmac at O'Hare Airport out there. There's 50 blowers and boxes of junk all over the place. And it's relatively quiet and warm in here.
Was it just your office, Judge, or were there multiple offices that the pipe?
Mostly the district court office and the jury room and the probation department. The ceiling collapsed into the lower level, and it's bad down there. They're going to be moving in the courthouse move, so we're just going to move them sooner rather than later.
I'm glad it wasn't a targeted hit, I guess, even though that makes it bigger.
No, it was just an old aging infrastructure.
Just leave it like that. Trying to keep my eyes open.
All right, so we've got everybody here. Let me make my notes.
Let them know today was my son's death day. Wish they would.
All right, this is file number 252647LT. It's entitled Vicki and Randy Demire versus, is it Randy?
Yes.
Demire versus Randy Winters and Patricia Winters. This is a termination of tenancy case. We are here on January the 9th. The Demires contend their house has been trashed and they wish the Winters to move. The Winters said that they had retained the services of legal aid, Adam Freeman. We've not received any appearance or any information from Adam Freeman. Rent was last paid in October of 2026 and none paid since. The lease ended December 4th, and the plaintiff simply wishes to terminate the tenancy. It isn't even just cause, it's just expiration of the lease. The Winters also contended they had contacted Fair Housing, and I haven't heard from them either. So, Mr. Dutka, what's the circumstance here?
Well, I think Your Honor put it in perspective. I think that's what we're basically moving forward with. This is the end of the lease, and it was decided before the end of the lease with the 30-day notice. It just wasn't going to be renewed by the Demires. And I think they had an absolute right to do that. The lease ended. Defendants are still in possession, and I think plaintiffs are entitled to an absolute right to possession.
Mr. and Mrs. Winters, what's your position?
Go ahead.
Go ahead, man.
Sir, we have two leases. I moved in December the 4th. I am aware of that. I got 2 weeks before court a notice to quit, and I felt that that wasn't enough time. And due to the circumstances, I have a lot of things going on. Today, I'm shaking because I lost my son. This was the day that I buried my son. He's a United States veteran, and I wouldn't have think that they would have. They knew too, because he came to this house and he seen my son on my wall. My son been gone here still like me. Oh my God.
All right, I can still hear you.
Oh my God. Could you just ignore that phone call? Because they trying to reach. No, leave it alone.
All right. They had asked you to move by December 4th and you didn't.
Yes.
And you're still there and they still want you to move. What's your position?
I came in here and I'm not a trashy woman. And it hurts me so bad for them to think of that, Your Honor. And the things that were said to me that is very, very hurtful. I have messages through my phone. I've reached out to Vicki. I've reached out to Mr. Demire with Vicki's number. I have messages. No one contacted me. I've been without a dryer here. I bought a dryer because it went out. I work every day. I've been have to go to the laundromat or hang my clothes up because they don't want to come down here and do the stuff that they need to do. I don't ask them for nothing. I fixed this place up. Me and my military grandson that is a lieutenant now. Me and him fixed this place up. They couldn't even get in here for 12 years. And then now they got in here. They see what I have done. They can make money on it. It was told that last year, in June or July, that they were selling this place. Right after I got done with court with you, Vicki started bothering me and harassing me again. I had my family, which is another military person from from New York, came down here. I got my church family here. They had the officers come here. I feel like that is very disrespectful, and I just want apology. I'm asking for time to get out of here. We have 2 leases. That's why fair housing is involved. The police officers are aware. I showed them my proof, and we could go further with this if y'all want to, because I got all the proof, and I am not a nasty woman. I'm a clean woman. I got a cleaning job, honey.
Well, they aren't contending that you are. She said that.
Very
I blurted it out. All right. Stop. They're simply saying, and one of the reasons is we want to sell the house. This happens a lot. The landlord has the house. They want to get out of the landlord-tenant business. Their health is failing. Other things are going on. They want to sell it. In order to sell it, they have to get the tenant out. They give you a notice to quit, saying you got 30 days to move. You didn't move. So they asked you to move by December 4th. That didn't happen. So they filed this action. We have a hearing January 9th. I adjourn it 2 weeks from January 9th to January 23rd. You still haven't moved. And the law now says you have 10 days to move or you're subject to being evicted. So you get 10 days from today.
Your Honor, can I speak?
Yes.
Your Honor, we have 2 leases.
That's why fair housing is involved. Go ahead.
We have 2 leases. You know what I'm saying? My lease and her lease, because she moved in first. So she have her own lease, then I moved in. So I have a lease myself. I wouldn't like to go off my lease. They just can't forge and say, this is my lease. I have my own lease.
All right, well, let's take a look. Randy Winter's lease agreement is signed December 4th of 2024 for a 1-year lease. It's got your signature only on it.
No, my lease was for March the 31st.
It's 2-4.
That's what my lease is supposed to. Do you have a paper bag?
2-4.
The lease I have in front of me is one for you, which expires December 4th of 2024.
I got it.
And I have a lease for Patricia, which expires December 4th of 2024. There is 2 leases, but they both have the December 4th date.
No, I'm gonna go further, sir.
I have a lease.
I'm gonna show you the lease. I have proof. This man signed the lease after me.
I signed a lease after her.
Where's my coat?
Right there, your pocket, your keys on there.
Where?
In the room on the table.
Okay. I got the lease. I got proof.
We had a lease right here, sir. We don't have no other lease.
It's a lot.
She have her own lease. I have my own lease. Mine's supposed to
I
be.
agree with that. I've got 2 leases, but they don't both say December 4th.
I know, first, because she moved in before I did. Then I came in March and moved in.
Well, your lease was signed on.
This is why I'm going further with it.
I have a document that I had the same one. I had the same.
I'm sorry. I'm trying to get it out. I have it right here. She switched it. That's why fair housing is.
I can't tell what day it was signed, but it ends on December 4th.
No, it's supposed to end in March.
You have this.
No, it isn't. It isn't. It says December 4th.
Well, I got Randy's. I got Randy's lease right here. Vicki forged that. And I will show you. I got Randy's handwriting and everything. I got 2 leases, 4 leases, 5 leases. She sent out different ones. I got the burden of proof in front of me. Please give me some time.
Say that again?
Please give me a little time to get it up.
She getting the lease up,
Please.
the right lease.
The lease that
All right.
Randy, when he moved in here, y'all cannot do that.
The lease that I signed, not the lease that she gave me. Don't say that she made up, the lease that I signed.
We went to court, and Judge Middleton should have the first lease that we had on the last one. But I'm looking through here. Hold up, I got it. I got it. I got it, baby. I got it. I really do. This is what the pastor said for us to keep, and I did. Right here. Hold up. December 4th. Oh my God, they just give me a minute. I'm quickly. I gotta get there. Hold up, I got it. I got it. I need my glasses. Yeah. Here it is, Daddy. I got it. I got it. Here you go, Judge. Where you at? Judge?
I
You
didn't
see?
go anywhere. You're like a cat on a griddle back there.
Oh,
getting on
I
a
move
griddle.
like that, sir. I move like that, sir. I got 19 grandchildren. I got to move like that.
All right, I
And
didn't.
4 of them is military. 4 of them is military, so I have to.
All
I
right,
have
well,
to do
so
like that.
what are you showing me?
I'm showing you Randy Winter's lease. Burden of proof.
All right,
No,
well,
This is Randy Winter's lease. This is what we got when Randy moved in
all
here.
right,
We
well,
got
what
10
is
leases in
it?
here.
When was it signed?
It was signed on. Hold up. We're at 1204. See, it's still coming up. There's that. That's not the one, baby. That's not the one. Get your lease out. You got to help
Yeah,
me.
that's December 4th.
This is December 4th. This is where she tricked. This is where she want to catch us up at. Please, Lord, help me. Here, hold up. Lord, help me. Here, come on. God knows. God don't bless no mess.
No,
Vicki changed
both of
this.
your leases say December 4th.
No, they don't. No, they don't, sir. I will fight this. I will take this all the way. I will
All right,
go
well,
to.
you do
I
have
will
a
go
right to
trial.
appeal it.
Yes, no,
But you
I'm
have 10
going
days to
trial.
move out or you're subject to being evicted.
No, give me
Your
your lease,
lease
Randy. They cannot do this. Or I'm gonna call the court. I'm gonna call the what's the name? They cannot do this. You got a lease that say 2-4. Vicki changed that. Vicki tampered with that. And the pastor got a copy of it too. That's the thing about it. That's the thing.
Well, I
'Cause they
don't
had to
see
have
it. All
for-
I see is what they filed. You can apply for an order of eviction
No,
after
sir.
February the 9th.
Sir,
This
is
has
not
been going on
true.
for
This is-
several months, several weeks.
No, they're
Your
trying to.
lease is
They're trying to say
expired.
that.
I don't have an escrow order. And both
gotta help
leases
me
were
find
signed
it.
with an expiration date of December.
Your Honor,
4th.
Your Honor, Your Honor, please don't do this. I have proof. Please don't do this. Give me time. I worked third shift. Please give me time to get this lease out. She changed this. She forged this, and I could get her on this. I have burden of proof. She's done so many leases here to mess us up and to flip us. And we got the first lease that when we first went to court, you got it. It's in your what's the name?
All right, well,
I'll
hold it.
I'll email you.
All right, please sit down so we can discuss this. You're very agitated.
I'm very because it's
you're
not
stop.
right. They're lying.
Stop.
The blood
Stop.
of Jesus. The blood of Jesus.
All right. There's 2 leases signed by each of you. Both are signed December 4th.
No,
so if
no.
you contend that his was signed on a different date,
Yes.
then I guess I'll kick you out effective 10 days and we can fight about him. But his lease also says December 4th.
But
And the lease that you found also says December 4th. So you have 10 days to move or you're subject to being evicted. No money judgment is entered here. You can appeal this. I suspect you're not going to find a lease with a different date.
Yes, I am.
I think this is the lease.
God don't bless no mess.
And
I
they've
believe
been
in
trying
God.
to get you to move since early November. You're both working third shift. You need to move. You need to move or you're subject to being evicted.
Okay,
I will
I'll tell
send
you
a
what.
copy of this order.
Your Honor, when I find this lease and I show you, all I want is an apology and that's it. And I want the Demires to know that I made their place the way it is because it was trash when I first came in here. If y'all give me, I will make sure that the carpets and everything and it's ready to go. If you're going to sell it, you sell it. If it's not, God knows. But y'all know y'all not right. If y'all could give me until February.
They don't have to ask for the writ on the 10th day. They can give you up to 56 days to move, but no rent has been paid since October. So you're living there for free right now.
No, I'm not, Your Honor. I have proof.
Of what?
I have proof the last time I paid Vicki was November the 7th. And I went to the bank.
Well, this was filed on. All right, so you haven't paid any rent since November. So we're now January.
She said that she wants me out.
December, January, and about to be February. The matter was filed with the court on December 9th. So some rent was paid. I don't know if that went to October. I think they said the last month that was paid was October. So, all right.
Your Honor.
Yes.
This is right. This is it. It says 2/1/25. Baby, I can see. Here's the lease, sir. You can put me out. You sure can. But God ain't gonna put me out.
I'm not sure what you're showing me.
This is the right lease. This is the lease for Randy Winters. He was 53 years old when he signed this lease.
All right, well, Randy has an appeal. You don't. Your lease expired December 4th.
I'll leave. I can leave. But you know what? I tell you what, ask the Demires if I do this.
Randy moved in on 2/2/24.
Yes.
Randy paid a deposit of $480, gave Randy a different lease but the move out date was the same. He did move in on 2/2/24, but the lease he signed expires December 4th of 24.
He didn't sign that lease.
On the real.
And if I might add, Your Honor, the paragraph she's showing the court gave Randy Winters until February 1st of 2025 to pay the security deposit.
And we paid it.
Okay, that's fine.
Yeah, so it wasn't the expiration date of the lease. It was the due date for the security deposit.
We paid it.
All right, Miss Winters, I wish you luck.
Thank you.
Thank you, Your Honor.
All right.
Thank you, Your Honor.
All right.
Doug, can you give me a call after we sign off?
Yeah, I'll call you, Robert.
Mr. Duncan, you provided a judgment. The date for the writ is February 9th. Mr. Demire, you may need to give him some leeway on a move out, but if you're going to sell this property, obviously it needs to be vacated. For what it's worth, it did not look trashed in the pictures from them. It looked like a decent place, but we'll see. Anyway, both leases expired on December 4th. The notice to quit was 30 days before that. They didn't vacate. December 9th, the action was filed. It's pretty straightforward.
So they need to be out by February 9th.
Or they're subject to being evicted. You can give them more time if you choose to. It's easier to have them move out voluntarily than to evict somebody. But February 9th is the date for the writ. The next day you could contact Sergeant Morse. All right, you're good to go. Thank you.
Thanks, Your Honor.
All right, Ms. Carr, why don't you come up here and you can have a seat right here. Our next matter and the final matter of the morning was set for 10:45. It's 10:48. Donna Carr is present. On this freezing cold morning.
And I filed an appearance in this matter. by representation last time, and then I followed it up with a paper appearance after that.
Meg Bauer is here for the defendant. Samantha Sprague is here from the Can Law Firm.
And Judge Attorney Sprague and I were on the phone earlier during those Golden Pond estate cases. That's why I turned off my screen. But I don't know that we were able to finish our conversation based on Attorney Sprague's own court obligations. But I don't know if anything's changed.
If we could briefly go into a breakout room, Your Honor, I do believe that we're really close to resolution. I'd just like to speak with Attorney Bauer before agreeing to an adjournment for us to finalize those agreements.
Very good. The problem was not Ms. Carr, it was her daughter Shandy Faulkner and her boyfriend Patrick Wilsey had moved into the apartment. Adult Protective Services was called into this matter, and the Colon Police Department with Chief Brinkert also responded for alleged assault on Ms. Carr by Ms. Faulkner, and it's not good. Ms. Carr, is Ms. Faulkner out?
I have no idea where she's at, Your Honor.
But she and Mr. Wilsey are out of the
They
apartment?
are out, and they're not coming back. I've done made that clear.
Are they evicted by the sheriff or police, or do they leave voluntarily?
She left on the 19th.
With him?
Well, he left before then. But
Did she take all of her possessions?
no, I'm gonna have to,
Judge, can I
figure
jump in
where-
here?
what I'm gonna,
Your Honor, that's why we need a breakout room.
All right, I'll put you in a breakout room and I'll wait here.
Thank you, Your Honor.
Ms. Carr, I'll just sign some orders while I'm waiting here.
yes,
My
sir.
office is a mess, so I brought everything in here. We'll wait for them.
When is the court moving?
Well, possibly sooner. The plan was early April. But some of the staff is gonna be moving immediately.
Yeah. Will it be in Centerville?
It'll be in the historic building across the street, or across the hall. The circuit court will be in Three Rivers.
Oh, I see.
The district court will be here in the historic building.
This building must be pretty old then.
Well, I came in 1978 and this building was done in like 75. So everything you see around the benches are new, but all the rest of this is original.
Three Rivers has a nice courthouse.
Yeah, the new one there, so we're gonna do some things from there. It's gonna be a rough couple of years while they renovate this building. We're all concerned. But when they finish, it will be quite nice, new, modern, better security, better handicap access,
Yeah,
better.
that'd be nice.
But I'll be gone before they get to that, but
You've been here a long time.
46 years.
Wow, that's a long time.
Well, you remember Judge McManus? I
Yeah.
succeeded him in 2002. I came here as a law student intern in the summer of 1980.
Where's your picture at?
I'm not gone yet. I have one that someone gave me, but it'll probably be in storage somewhere while they tear this building apart. Someone gave me a nice one, the man that did the photographs, and I can't accept gifts, so I accepted on behalf of the county. So I got a portrait.
Judge, Ms. Sprague is just briefly communicating with her client. Ms. Carr, sorry, Judge.
I put the manager in the timeout. Maybe they're on the phone. All right. Ms. Carr is here with me.
So, Ms. Carr, during the remainder of these proceedings, let me do the talking. Obviously, unless Judge asks you a question directly, and then you and I are going to discuss a couple of things afterwards.
Yes, ma'am.
Okay.
Meg, are you gonna need the breakout room for your discussions?
If the court can spare the space and time afterwards, that would be helpful.
Yes, Laura, could you open the Zoom room, please, the conference room?
I will confess, Judge, I went back and forth on driving, and if the court was going to be closed, I figured it wasn't going to be closed until I was halfway there.
We'll make it work. We've managed to accomplish what we needed to. I don't know what's going to happen with poor Mr. Stroop.
I don't either. Thank you, Judge. Attorney Sprague, are we ready to go or no?
We are ready, yes.
All right. Laura, I don't know if you heard me. I asked if you'd open oh, there it is. Thank you. All right. We return to Mr. Grove versus Donna Carr and Shandy Faulkner. Attorney Sprague and Attorney Bauer have been discussing the matter privately in a breakout space. I'll defer to you, Ms. Sprague. What's our status?
Yes, Your Honor. We do appreciate the court's time in allowing us to speak within the breakout room. We do believe that there may be the potential for a probation period to be entered in here. Plaintiffs has some concerns because to our knowledge, the individuals that we were led to believe had moved out were actually seen on the property yesterday, and a police officer had notified my property manager that Ms. Carr was not cooperating with police officers that were seeking Ms. Faulkner. And so, and they're regarding another issue, and they believe that she may have been harboring her. We are cognizant of the unique situation that Ms. Carr is in, and so we would like to provide some additional time to see if compliance can be made before we enter a formal probationary period. For that reason, we are respectfully requesting at least a 10-day adjournment, during which time we will get the writ over to the court today and make attempts to get that writ executed and ensure that Ms. Carr is complying with the removal of Ms. Faulkner and continued absence of her before we put a formal probation period in place.
All right, I received a date stamped today, a report from Chief Brinkert, the Colon Chief of Police, who's been there for a long time. He was there yesterday, January 22nd, and from the report, it's in his opinion, Ms. Carr was assaulted by Shandy Faulkner and had some serious concerns about that. And Adult Protective Services was contacted. And there had been some allegation that she was there yesterday.
Judge, was this report provided to you by the officer sua sponte or by Attorney Sprague or some other way?
I think it was provided by Adult Protective Services. There's also an adult PS file. I don't know. It just showed up and it was handed to me.
Okay.
Ms. Sprague, do you have it?
I don't have a copy of it, Your Honor. We were going. I was just made aware of the police officer's presence during the breakout.
And Attorney Sprague and I have a good professional relationship, I think. So I trusted that it wasn't from her, but just kind of curious where it came from.
All right, Ms. Carr, the bottom line is Ms. Faulkner and Mr. Wiltsey need to be out of there. If they have some concern that they're coercing their way in there and frightening you, you're going to get evicted. You're going to be homeless.
Yes, she has threatened to break the patio door glass if I didn't let her in. So I'm not letting her in, and if she does that, I'll just call the police.
All right, well, we're going to adjourn this 10 days. Let's see what we got here. But I don't want anything to happen to you.
And Your Honor, if I may.
Yes.
I know Ms. Bauer has probably already coached her or provided this information, but when a police officer is at the door, if there are individuals within the home that may cause an assault, that is a perfect time, in my opinion, to present that to the police officer so that way they can clear your home and you can maintain a safe environment. And so I'm
Yes,
not sure if
over.
that's what happened, but we would just like to reiterate our encouragement of that, management's encouragement for her to conduct that.
All right, 10 days from today would be February the 2nd. Let me see what that Friday looks like to see if you guys are scheduled to be here for anything else. Probably not, but let's take a look.
And Attorney Sprague, I didn't ask you about this when we were discussing, but I don't know that we ever got a copy of the default judgment.
The default?
That entered at the first hearing against,
I can provide a copy today. I don't know if it was, I don't know if, I know it was uploaded on my file, so I'm not sure if it was also sent to your office. I'll confirm.
Have my file in this district.
Oh, then let me see where we
Yeah, I
submitted
have
it
a
then.
copy dated a default as to all occupants other than Donna Carr.
Okay.
So that writ needs to be served on her. February 2nd is a Monday.
And that
And I
writ
don't
would be
see,
effective
Ms.
immediately.
Sprague, that you're set to be here at any other time. So how about if we go to 2:45 on February 2nd?
February 2nd, 2:45. That would be perfect. Thank you, Your Honor.
All right, Ms. Carr, I'm going to ask you to go into the conference room.
Okay.
And I'll let you speak privately with Ms. Bauer and you can discuss your options here. Cynthia, you're on top of what's going on there on the ground. Certainly if she's seen there, she's subject to being evicted and she's a trespasser. And if she is in fact committing assault, there may be other criminal ramifications to this. But for now, we'll continue this to February 2nd at 2:45 p.m. And I will see that both attorneys get a copy of this police report.
Thank you. And Ms. Bauer, I just forwarded that initial judgment over to you as well. And then we'll be in communication regarding the execution threat.
I appreciate that. And Judge, do you have the writ in front of you? And
I have to submit it.
Has to be
I
submitted.
do.
Oh, did we submit it already?
The writ was
the 19th, I believe.
Yeah.
19th, yes. I wrote,
Okay.
yeah.
We'll get that over.
January 19th, that date is passed.
Judge, my understanding is that there will be a writ forthcoming, hopefully today, if Your Honor is still in the courtroom or in the courthouse.
Yes, I certainly would sign it. We don't have a writ. So yeah, when it gets the writ, plaintiff will submit writ.
Okay.
All right. Thank you for joining us this morning. We'll be back at 2:00 with further Colon Township versus Yoder proceedings. This is another continued hearing in the matter of People versus matter of Colon Township versus Alfred E. Yoder and Joanne Yoder. There are two files, 25040CZ and 25533CZ. These are circuit court matters. I inherited this case earlier this year from Judge Stutzman when he disqualified himself, made a number of rulings, had a number of hearings. Keep hoping this matter will be over and completed. And the defendants have filed additional pleadings. I'm not sure I exactly understand everything. And then again, some pleadings were filed just the other night, January 21st, which was Wednesday before the pipes broke. So I had made my rulings. Mr. Thornton, on behalf of the township, submitted the orders for presentment. Defendants filed these additional pleadings, and here we are again. Mr. Thornton has filed a response pointing out the irregularities in the defendant's motion and pleadings, and he's asking for sanctions on behalf of the township for continuing to have to come back here regarding these motion hearings. So, Mr. and Mrs. Yoder, you're the motion filer here. What are you asking me to do?
Your Honor, we're here on our written motions challenging the accuracy of the proposed order and opposing sanctions.
All right, what's your challenge to the accuracy of the order?
It's very misleading. And it does not match the transcript, not even close.
What part of it don't you like?
Most of it.
Well, my reviewing of it is it was consistent with the orders I made here in the courtroom. They don't have to exactly track what was said in the courtroom. You filed these pleadings, and as I've said repeatedly, someone's helping you, someone without a law license, but access to Chat GPT or other AI generated stuff. They're terrible. Their pleadings are terrible. They're leading you down the incorrect path. They're going to end up costing you lots of money. And they filed fraudulent or incorrect, at worst, fraudulent, at best, incorrect or lazy or incompetent pleadings on your behalf. They cited authority that doesn't exist. Anyway, and then they can't speak for you because they aren't lawyers. And I can't go back and redo the past. I told Ms. Wurtelman this, I told others. If you had a competent lawyer at the start, we'd have been a lot better off than we are here.
What, Your Honor, what do we have missing?
All right, well, we'll get to that. All right, so you tell me you file these things and you object to everything in the order. You don't like anything that's in it. I need you to be a little more. Now, you do have these pleadings that you filed, which state these things. All right, well, all right, so you've got defendant's motion order to show cause in 2540 and 25433. And you've got a motion to strike proposed order of December 4th. Law requires that a written order match the oral ruling. Proposed order mischaracterized what the court actually did. The judge may not mock himself to avoid judicial duty. And then eventually you object to the entry of proposed order. So that's the first thing. You're objecting to the entry of the orders. Mr. Thorne, what's your response?
Your Honor, the court's rulings in the hearing held in both of these cases on December 3rd of 2025 were not extensive or complicated. The two proposed orders that I prepared at the court's request with regard to the denial of the orders motions on December 3rd, 2025 are brief, accurately reflect the court's rulings on that date, and if the orders had competent counsel, would have entered without objection. Well, that has not been the history in these cases. Instead of those simple, straightforward orders being entered by the court, the orders file a motion to strike, 9 pages long, a motion for an order to show cause, 6 pages long, objections to entry of proposed order, 8 pages, and then a week or so later, an affidavit of factual observations, 5 pages. The orders in violation of the court rules then failed to follow the court rules by failing to serve those documents on me as the township's counsel of record. The orders in violation of the court rules to file with the court or serve me with a proposed order that they believe complies with the court's rulings on December 3rd, 2025. And they failed to follow the court rules to schedule a hearing and file a notice of hearing regarding their motions. I think they belatedly, after the court scheduled the hearing on its own, did eventually file a notice of hearing.
I advised them that they hadn't filed a notice of hearing. And then they said, well, what do we need to do? And I'm not sure, but I think then they tried to remedy it.
It's been my experience that when a party fails to set motions for hearing, fails to file a notice of hearing, and fails to file an alternative proposed order to the order they're objecting to, the court would not set a hearing date to the multiple, due to the multiple court violations. However, that is not the case in these cases. The history in these cases is that no matter what the orders file, no matter how many court rules are violated, the court sets hearings and Colon Township is required to defend. In addition to the above, the Yoder's motion to strike includes an alleged quote from Tiedemann v. Tiedemann, 400 Mish, 571, 1971 to support their motion. The quote, and it is a quote in their motion to strike, does not exist in the Tiedemann case, and the subject of the quote isn't even a holding in the Tiedemann case. In short, the Yoders either intentionally or through gross negligence attempted to mislead this court. The Yoder's motion to strike includes an alleged quote from a case they captioned In Re Estate of Temple Marital Trust, 278 Mishap 122, 2008 to support their motion. This case, the case with the site of 278 Mishap 122 is actually captioned Temple v. Temple, and the quote in the Yoder's motion does not exist in the case, and the subject of the quote is not even a holding in the Temple case. The Yoder's motion to strike contains an alleged quote from an alleged case captioned Palazzolo versus Gorsica with an alleged site of 200 Mishap 27, page 271, 1993 case. I could not even find that case by searching the names or the site. In short, the Yoders and those persons assisting them believe that when this court holds a hearing on a motion and makes the rulings on that motion, the order entered by the court in regards to the hearing must mirror the transcript of the hearing word for word. I refer the court to page 7 of the Yoder's motion to strike, where one of their relief for request states, direct plaintiff's counsel to submit a corrected order that mirrors the transcript word for word. As the court is aware, there is no court rule or statute that requires this, and to my knowledge, there is no Michigan court that would require this. If this were the case, then a transcript would be prepared after every hearing, and the judge presiding over the hearing would simply sign the transcript. After I filed and noticed for hearing my motion for sanctions, the Yoders filed an objection in response to request for sanctions, claiming there is no basis for sanctions. MCR 1.109E states, the signature of a person filing a document, whether or not represented by an attorney, constitutes a certification by the signer that, to the best of his knowledge, information, and belief, formed after reasonable inquiry, the document is well grounded in fact and is warranted by existing law or a good faith argument for the extension, modification, or reversal of existing law. I'm going to go out on a limb and say, I don't think the Yoders or whoever prepared these documents on their behalf ever read the cases they were citing. If they did, they have committed intentional fraud on this court. On behalf of Colon Township and its taxpayers, I'm requesting that this court enter the two orders I submitted that accurately reflect the court's rulings on December 3rd, 2025, and grant the township's motion for sanctions, ordering that the Yoders pay additional costs and attorney's fees to Colon Township in the total amount of $1,624.68, which is the actual cost that Colon Township and its taxpayers have incurred in these matters since December 3rd, 2026. I would propose that that amount of $1,624.68 be divided between each case, since the motions were duplicated in each case. That half amount would be $812.34 in each case. Thank you.
All right, Mr. and Mrs. Yoder. The two orders that were presented, as Mr. Thornton stated, are brief, concise, and consistent with what the court ordered on December 3rd. They're asking for sanctions. We cited the rule. The person signing, for one thing, you're never very good on the procedural stuff. Getting notices, filing notices, getting dates, serving the other party. And he objects to my setting these things without you doing it right. Judge Stutzman might have just bounced it, but I wanted to get it to the next step, which is where we are now. But I would like to, at some point, have closure to this. You do have a right to appeal this. This is a circuit court case, so the appeal would be to the Michigan Court of Appeals. In a district court case, the appeal is to circuit court. This is a circuit court case, and the next level of appeal would be the Court of Appeals, and those procedural rules can be very difficult. So you filed your pleading stating your position. Mr. Thornton filed his responsive brief stating his. He's asked for sanctions, saying that you filed false pleadings. There's no merit to the pleadings that you did file, opposing these orders, which in my view are consistent with what I ordered on the record. So he's asked me to order you to pay $1,624.68 divided between each case. You did file a document called Objection to Sanctions. Let me take a look at that. Sanctions are not warranted under 1.109E, as he cited. Defendants were expressly authorized to file their motions and objections. Plaintiff does not deny the core factual issue accuracy of the proposed order. Yes, they do. The plaintiff does deny the accuracy of your contention that the order was not correct. Alleged citation errors do not support sanctions. Whoever's filing these pleadings, if they were an attorney, they could be subject to sanction from the Bar Grievance Commission. But these people aren't attorneys. There's not a crime. There are sanctions that can be done for practicing law without a license, but so you filed your responsive brief with your assistance. And is there anything else you'd wish to say regarding?
I guess our motions basically speak for themselves.
They do.
And I object to what he just got done saying, and I would like to have the objection noted for the record.
It is.
I say the order that he filed was very misleading. And the reason I say that is it doesn't have to mirror exactly what the court said, but I have the court transcripts for that day. And if you add or delete a couple of words, it will change the meaning of the whole thing. And that's why I say the order is misleading.
Well, here's what it ordered in each case. The defendant's motion identified above are denied in their entirety. And I denied all your motions. The order following hearing held on December 15th and entered November 5th shall stand as ordered. That's what I ordered. The restitution ordered in paragraph 1 of the order following the hearing on 10/15 shall be paid on or before January 2nd. No additional costs are ordered. That's what I ordered. There's nothing untoward or misleading about those. Defendant's motions identified or denied in their entirety. The defendant's order, the court's order held on October 15th, entered November 5th, shall stand as ordered. I'm going to sign the order in each case. Today is the 23rd of January. In file 25040CZ, again, restitution ordered in that case shall be paid on or before January 2nd. That's not plausible. I'll make it due by 21 days from today. Today is the 23rd of
And Lance said that they couldn't even find that one case.
Yes.
That we had listed. Well, I guess that's amazing that an attorney can't find it, but a dumb Amishman can find it.
That case would be
Right, there it is.
Palazzolo versus Corsica.
To the best of my knowledge, I did not file anything that did not match with the paperwork.
Yes, that's to the best of your knowledge. Somebody's leading you down the pea path by doing bad lawyering.
But I guess the court order that I got had more writing in it than what you just read. I was gonna bring that order along and I didn't, I forgot it.
These are the two proposed orders that were objected to. Is that correct, Mr.
Well, the court order that I got, it's got more writing in it than that.
I can state for the record, the order I sent to them under the notice of presentment was the exact same orders that were submitted to this court.
And it says more than what he just read.
Well, the ones I'm about to enter say exactly what I said.
And I guess if you look up sanctions and the rules and regulations for sanctions, sanctions require filings not grounded in fact or law. These filings are expressly authorized by the Michigan court rules.
There is no Palazzolo versus Corsica under that citation. David Corsica was the Oakland County prosecutor at that time, was a friend of mine.
And there was one other one. Show cause motion cites MCR 2.114E, which is a court rule that has been deleted since 2018. I guess I read that one. I checked even on that one. The rule was moved to MCR 1.109 effective 9/1/2018 and is still in effect under that rule.
Defendants' motions objecting to the entry of the order are briefed and preserved, and their objections are preserved. Those motions are denied, and the order shall enter as ordered by the court on December 3rd. The motion for sanctions is granted. The court will apply $812.34 per case. The others are due by February 21st. Those are also due by February 21st.
Your Honor, yes, in order to try to avoid this whole situation again, I've drafted and prepared orders that you could look at right now if you wish to.
Yes, I would,
That
thank
would
you.
prevent me from having to submit it under the 7-day rule, objections, and another hearing.
You have a right to appeal this. You have moved your birthing center, as far as I can tell, from that location. There is a need or demand or for your service. Just couldn't do it there.
Those are identical orders, Your Honor.
All right, let's review it. Did you give them a copy?
I didn't.
Do you have one for them? I don't. Or would you make copies for the defendants? Follow along while we enter them. I'm just trying to get the orders entered and finalized. If you wish to appeal it, you have that right. The appeal, as I said, would be to the Court of Appeals. The effects of the orders have mostly been accomplished. So we'll see where this goes. So these will be final orders that you can use to appeal my ruling. And I know you disagree with it. That's your right. The other stuff is just static. The orders are brief. They're straightforward. I believe they comply with what I ordered. I'm not sure what you're referring to as change a word here or there. Those orders are quite brief. And
well, like I said, the one that I've got had something in with motion with fraud was denied. I forget what all it was, but there was a lot more stuff than just what you read.
And its motion to strike proposed order, and these are parallel. One is in 25040 CZ, one is in 25533 CZ. Paragraph 1, the defendant's motion to strike the proposed order of December 4th filed with the court on December 10th is denied. Defendant's motion for order to show cause filed with the court on December 10th is denied. Defendant's objection to entry of proposed order filed with the court on December 10th has been found to have been filed by the defendant without legitimate basis for filing an objection. Plaintiff's motion for sanctions dated January 12th is granted on the basis that the defendant's motions and objections were signed in violation of MCR 1.109E. Shall pay to the plaintiff. They've got 30 days in here and I'll leave it. $812.34 in each file.
What was the amount to put in there?
$812.34. If you double it, it's $1,624.68. That order is signed in file 25040 and in 25533 CZ. I hope this brings closure to the circuit court. Activity in this file. If it goes to the Court of Appeals, that's outside my province. They can review it. All of these issues have been preserved by your pleadings. So there are 4 orders entered today. The original order following the hearing that was submitted under 7-day rule that you objected to in file 25040 and 25533. Then I filed 2 additional orders, again in each file following this hearing. So you owe the restitution in the original case by December 15th, and you owe an additional $1,624.68. If you object to it, appeal it to the Court of Appeals. They have jurisdiction to overturn my ruling. They may view the matter differently than I did, but any further pleadings in this court could be met by further financial sanctions. All right. We'll get you copies of each of those orders. And we'll go take these up and file them with the clerk. And we'll get copies right now for the orders while they're here. All right, Mr. Thornton, thank you for the original orders and thank you for preparing those additional orders for today. You're welcome. All right, we'll be in recess.
Well, that's how the cookie crumbles. Oh, I did that all wrong. I just messed everything up. Right here at the very end of the show. That's how the cookie crumbles with the Yoders. Wow. What can I say? The Yoders had no counsel at all, but the city of Colon had a private counsel that just was not going to let things go until he made a point that using fake information that is made up and hallucinated by artificial intelligence that does not bother cross-referencing case information to the real world, because it does not have access to LexisNexis and all those cool things that could allow it to do that. Well, I guess the Yoders found out that when you do those types of things, even as a layperson, even as a very staunch, believing individual, beliefs just don't matter. You can still be sanctioned just like a lawyer can. In the rest of those landlord-tenant cases, oh my. There's apparently some more to the Winters group. There's a whole nother case. Hutch will be having that, so keep an eye out on his channels for that. We may actually look for the other cases and see if we get a supercut put together and just to have something to do while the big winter storm's coming through and all. But, you know, we got about 13, 14 more hours here. We'll be right back live again. Weather be willing, power be on. And yeah, we'll be doing a weekend live, and I have some crazy cases. We're going to be doing Simpson and the 401k property case tomorrow, along with some other stuff. There might be an elderly lady who we've seen bring mice to court before, and other things. I have other things planned. Some Judge Johnson, some Judge Stevens. Yeah. So, if the power's on, if the internet's working, we'll be here, ladies and gentlemen. It's been my pleasure to present these daily cases from today's dockets here at the Court Gallery. I am your Lone Wolf Usul, and yes, Mama Pitt, we are talking about Ms. Pope. Miss Tope. Did I say I said Pope? I meant Tope. Yes, we're talking about the 401k Tope case. We'll see it tomorrow. It's going to be here. I want to show it just so we can all comment on it together. Even if we've all seen it. I haven't seen it. I've seen parts of it. But I know it. I know it's wonderful. But ladies and gentlemen, I'm your Lone Wolf Usul. I'm your host for these here videos. I am your curator for this here channel. And I will be back with you tomorrow morning with a weekend review. And I will see you then. But for now, I am out. I'll see you later. Have a good night. I got nothing. I'm sitting here thinking to myself, what am I going to do for the Ferris Bueller day off reference tonight? I got nothing. So be safe, be weather conscious, and stay warm.